petition me, I just might abate some of that fine. Well, if you abate some of it, would you abate all of it? No, I don't know. Try. Now, it was the judge in a private conversation, and Nick that said that. Nick didn't ask him for anything. And Nick got in a short conversation going, oh, well, he says, thank you, Your Honor, I may just do that. And the judge looked at him and said, do us a favor and just hire a lawyer to do it. Have him petition me. Well, you know, 6 months ago, we'd all probably gone, oh, there it is, that's the trap, they want to do something. Instead of abating, they'll probably get you in jail now because, ha-ha, you hired the lawyer and you're screwed. But Nick says, no, it actually looks like this judge is trying to give us some pointers and some things. See, it started out in the original act was private. Then the public didn't like it, so they charged him in public. And then you came back and accepted and returned it in private to offer the settlement. And when the settlement was agreed to, they came back in public for the trial and found the defendant guilty. And then you accepted that in private, and then you came back in public for the sentencing, which was a public sentencing, after you made a private statement called allocution. And the public sentencing came out and really gigged the straw man, the defendant. And then after everything was settled and closed, the judge saw Nick privately in the hall, said, come on back privately and we'll see what we can do about abating part of the public sentence. So this thing keeps going back and forth. Public, private, and all the real action is getting done in the private. The public is just a mimic. It's just there, just like the Matrix, to keep everybody asleep in their cocoon, not shaking the structure whatsoever, and everything's getting done in the private behind the scenes. Now the problem is when some of these people are going into the public hearings and they're starting to try to argue their private rights, all of a sudden it shuts the public down and it sidetracks what's going on there. So some of us were trying to look at what's going on here and how can you have a little bit of a roadmap to understand what's happening so that you're not totally in the dark. So at least hopefully you'll know a little bit more about what they're doing and what's expected of you. And so I was talking to Nick this week, and here's one of the things we came up with. First of all, the trial deals with the charging instrument. And who is the charging instrument against? The defendant, the straw man. When it comes to the sentencing, they have a charging instrument in the sentencing too. What is the charging instrument in the sentencing? The probation report. It's not the judgment. The judgment was the conclusion of the trial. And remember, since the public is bankrupt, they can't execute on their judgments. There's no money, so there's no executions. They can't carry it out. So the judgment is the end of the trial, which deals with the defendant, which is the straw man. The sentencing hearing deals with the offender, the living man. And the charging instrument going into the sentencing hearing is basically the pre-sentence probation report. What happens is, of course, the pre-sentence probation report is basically a write-up on the history of the defendant and what all the witnesses say about, quote, the defendant and all those things that have happened. In the pre-sentence report, they go back to previous government law enforcement records They do an interview with the offender. They do interviews with other people that know the offender. They do interviews with the victim of the defendant's actions, etc., etc. And all of this is brought together along with the government recommendations for sentencing based upon the finding of guilt or the confession of guilt by the defendant in the court proceedings. And what the pre-sentence probation report does is really appraises or evaluates the commercial value of the so-called crime, so that it's an appraisal instrument. Now remember, when Elvick kept talking, let's say a couple years back, when we were talking about the whole concept of everything in civil and criminal being commercial, Elvick said that before you could do an acceptance and a discharge, you needed to have a firm offer. Most of the problems are you can't pay a bill you don't yet have. And I think, did I not tell you guys last week the story about the guy that's in the bankruptcy proceedings out west? And he's trying to bankrupt his criminal case conviction? Did I talk about that? Yeah. And what happened is this guy had two hearings. He had a Monday hearing and a Wednesday hearing. And the Monday hearing, he was in the state court for sentencing on the criminal case. And on Wednesday, he had subpoenaed the prosecutor from the state criminal case to the federal bankruptcy court to request the prosecutor to bring a claim, if he had any claim, against our hero. And when he appeared at the Monday sentencing, he was the guy that basically said, I don't care what your report says, just sentence me. And when the judge refused to sentence him because he dishonored the court by not reading the report, he was never sentenced for that state crime on Monday. When he went into the federal bankruptcy court with the prosecutor on Wednesday and had the prosecutor show cause why the bankruptcy court shouldn't discharge that liability, basically the judge in the federal bankruptcy court kind of turned some of the wording around and said, we're not going to stop the state court's actions. Didn't say we weren't going to discharge the liability in bankruptcy. He said, we will not stop the state court's actions. Why did he say that? Well, the feds don't have any authority to stop state court actions. There was no claim because there was no judgment. So the bankruptcy court didn't have anything yet to discharge. So instead of saying we're not going to discharge the liability, if in fact one ever exists, the federal judge says we're not going to stop the state court from proceeding. So this guy was his own worst enemy. On Monday, he didn't get the judgment. So on Wednesday, there was no claim to discharge. So they didn't let the cat out of the bag. The federal judge didn't say, come on back when you get a judgment. He just said, we're not going to stop the state court action. We're going to let it proceed. So the point I'm making is, you can offer, let's say they come down with an indictment. Is an indictment a firm offer the way they do it? No, because it's not a firm offer. It's not even an indictment. It's just a piece of paper. It's an offer. It's a commercial offer. Okay? And so when do you finally get a liability that arises from that offer? When you get the court judgment. There's not a firm offer until the judgment comes down. Well, judgment. Then they appraise the judgment with the sentencing. And it's the appraisal of that judgment by the sentencing report offer that is the firm offer that for the first time you've got something you can work with in discharge. Up until then, that's why they keep saying, well, you know, we don't know what you're talking about. And they can say it with a straight face because it's not a firm offer. Okay, we don't know what you're talking about. You sound crazy to us. You do what you have to do, but we're moving forward. And if you want to plead guilty, that's fine. See, the issue is you're pleading guilty to a fiction. It doesn't exist. The problem is the patriots want to go out there and argue why the fiction doesn't exist. And by arguing that the fiction doesn't exist, you've made the fiction real, irregardless of your argument. So it's one of those catch-22s. If you recognize it don't exist, but you argue it, then it does exist, so you can't get rid of it. Since it doesn't exist, if you accept it for whatever capacity it is, then they will never argue with you. They'll carry the play through to finality. And because you haven't argued with the illusion and they know it's an illusion and therefore they're liable, they'll just go through the rest of the play and then discharge you. So it's one of these catch-22, as Heller would say. That's quite some catch. If you try to argue the reality that it's an illusion, then it becomes the reality. But if you act as though the illusion was the reality, then it goes through on the public side as a reality, but you go home because everybody agrees it's a mere illusion if you've done it right. So it's all backwards. It's through the mirror. So what we're saying is that the complaint, the citation, the charging instrument is the offer in the trial, and that only is set there to trap the defendant, never the living soul who is the offender. That when it finally goes to a judgment and an appraisal by way of the offering in the pre-sentence report, that's your first absolute firm offer, by which when you go into the sentencing, you do the acceptance and a return on that, and you play your little game, which really is not a game. It's very real in that you're demonstrating that you understand honor and are willing to give it. And then you should get your remedy at the end of the sentencing hearing. And then it's irrelevant and immaterial really what the punishment was. It was going to be dealt. Some of the guys that were going into their sentencing hearing started falling into this patriot type concept that goes, well, the report says that the defendant is wicked, terrible, and awful. The defendant, particularly with malice and everything, did the act in action, and they lay the charges in the pre-sentencing report on so thick that you go, I don't care what anyone says, I can't admit to that the way that is, because if I admit to that the way that is, I'm really screwed. But you've got to go back, and it's going to be the same thing in the charges of the pre-sentence report as the charges that are in the information, indictment, complaint, whatever it is. There's going to be adverbs, adjectives, conclusions of law in there that's going to make your blood boil because you know that's not real and that's not true. You're not here to argue the facts in the pre-sentence report any more than the defendant is there to argue the facts in the charging instrument. All you can do is accept it. The main facts that are not conclusions of law will absolutely all be true. The conclusions of law and the adjectives and the adverbs will be way out in space. But they're irrelevant and immaterial to your acceptance. and asking for settlement and closure. So one of the guys in the settlement was going, I can't agree to this. This is totally wrong. They didn't get this anywhere, and this is not even the agreement. So I'm going to put into my allocution where that's not right. And I'm going, no, I don't think so. You can do what you want to do, but if you start arguing the presumptions and the issues in the charging instrument of the pre-sentence report, you brought your warfare from the trial to the issue of sentencing, and you're in dishonor again. The facts are on the moon. It's irrelevant and immaterial. Just accept it and then do what you need to do on the public side to finish out the play so you can go home. And thank goodness the one or two people I talked to about that saw the light and went ahead and did that. And they've come out pretty good in this. Now, since we know that the sentencing deals with the offender and the trial deals with the straw man, you got to remain honorable through this whole thing. And when it comes into the allocution, what you got to look at is the overall picture. Now, what's the overall picture here? Remember, you do an acceptance and a return. But there's a lot of people out there in Never Never Land that have done acceptances and returns, and they're in jail. All we have to do is remember Richard and Joni and a lot of other people that have gone in and done acceptances and returns and told them, release the order of the court, and it just didn't work out for them. Now the issue was, what happened? There is a common law pleading that's called confession and avoidance. Admiralty has its roots in the common law. And admiralty is only as good as a law form as its capacity to extrapolate on its roots that come from common law. Now, there was a pleading in common law called confession and avoidance. And that's exactly what's going on in admiralty equity courts today. Now, in confession and avoidance, if you look that up in the dictionary and find out what's going on here, they'll tell you that the confession is basically a legal fiction of law. What is a fiction of law? A fiction is something that the lawyers and the people processing law developed that didn't exist. And the reason they developed a process that didn't exist is because otherwise they couldn't provide a remedy. There wasn't any remedy. So they had to create a fiction of law to provide a remedy where none existed. Let's try to explain what's going on here so that we're not all confused. In 1933, when Congress declared that no longer is it the public policy to pay our debts at law, HJR 192, what they basically did is they ratified the presidential edict of the withdrawal of the gold and silver from the monetary system of the states. They got rid of the gold and silver lawful coins of the United States. Now, all court actions, all court judgments are basically denominated in lawful money of the United States. And there's plenty of case law pre-existing 1933 that basically said that they could only execute judgments in terms of lawful money. So when lawful money as a public policy, as a result of the bankruptcy of the corporations, was pulled out of existence, what that basically did is it destroyed the ability of the common law courts to execute their judgment. So if the common law courts can't execute their judgment, why should they even bother having judgments? Why should they even hear a case? Because there's no way to get a remedy. Oh yeah, we fine for you. You get to collect from the other guy $1 million. Okay, the only problem is there's no lawful money anymore, and since we're state courts, we can only execute with lawful money. And since there is no lawful money, too bad, buddy, you got a judgment. Just keep it around. We hope you live long enough that lawful money comes back that you can execute. So now they basically put the courts out of business. Well, you know that ain't going to happen. So they got to create a fictional law whereby they can give the courts the presumption of a capacity to operate. So under the fiction of law, in this case a fictional law, under common law, pleading, confession and avoidance, what would happen is the plaintiff would come in and he would establish a series of facts in his complaint. And then he would attach that to an operational law and ask the court to award the facts to be true in his favor and deserving of the execution of the award under the operational law. Now the defendant would get a copy of that pleading, and what would happen is the defendant would look at it and go, no way, you wrote a bad contract here, this will never fly. See, in common law pleadings, you had a first pleading, a response, and a changed pleading, a response, a changed pleading, a response. What they were doing is going back and forth until they eventually wrote a perfect contract. There was no mistakes in the pleading, so that the defendant could say, okay, you got everything right, I've agreed with you, now let's go ahead and execute. So they were attempting to write the perfect contract. Now the court said this is stupid because it takes years to get a perfect pleading to move this case forward. Why don't we just create a fictional law saying that there's going to be one complaint and one answer, so that we can trim down the pleadings time, and we don't care if the complaint or the original pleading is perfectly correct or not. So what happens now is if you can write a pleading that says the defendant is Caleb and he's a white male and we think he robbed us, that should be sufficient as a complaint. Now you can come in and do whatever you want to with that. Okay, well the fact that Caleb is a male and he's Caucasian is true. The fact that he presumes he robbed you is a conclusion of law. So is it every fact in the complaint true? Absolutely. Every fact is true. So now what they do when they wrote this stuff after 1933, they said there'll be one complaint, there will be one pleading complaint, and there will be one answer. And by the time the complaint and the answer come back, the court's got jurisdiction. So what happens is you confess the truth of the facts in the charging instrument, which we're going to call a fiction of law, because it really didn't charge you with anything. There were no true facts there that charged you with anything. They were all conclusion of law. But in order to give the court jurisdiction so that you as the offender could get the court to throw out the idiot plaintiff's complaint, you've got to confess the facts in the pleading to give the court jurisdiction so that the court can get rid of this thing and let you go home. Because the oxymoron is if you won't give the court jurisdiction, they can't help you, and now it drags out forever. So you confess confess the facts in the charging instrument are all true. Now the court's got jurisdiction, and I'm sure the judges are going, so he's white, so he's a man. Where the hell is there evidence that he ever robbed anybody? We think we ought to dismiss this for failure to state a claim. And that's what the court's thinking. And since you, the offender, gave the court jurisdiction to help you, they now have the capacity to do this. Now the oxymoron is if you don't confess and give the court jurisdiction, you're in dishonor to the court trying to help them out. And even though the court's going, well, why didn't he just give us jurisdiction so we could dismiss it? The court's going, he's in dishonor, he won't help the court, we gotta put him in contempt. Yeah, purgatory for not being nice, okay? Now, remember the common law pleading is confession and avoidance. The pleading is not called, well, let's go in there and do the confession pleading. If you go in and do the confession pleading, the first thing they're going to say is, oh, you admit the facts and you're the robber? No, I'm just confessing to the facts. But then they're going to go, you can't just do that. You've got to confess to the whole thing. Okay? Now remember, equity admiralty is an extension of the foundation in common law. So whatever you're doing in equity admiralty has to come from the common law to develop the process either to get you in trouble or get you the relief. So in common law they have confession and avoidance. So what is the confession part of the pleading? The confession part is, I accept and I return. So when you're doing an acceptance for value and a return for value, and you're seeking settlement and closure, what you just did was the confession side of the old common law pleading of confession and avoidance. But all those patriots that are doing nothing more than I accept for value and return for value, I ask for settlement and closure, all they've done is half of the pleading. They haven't done the other half of the pleading. It's the other half of the pleading, the avoidance, which you need to put before the court, which is going to keep you out of jail. Otherwise, your confession, oh, you admit to being the thief, hasta la vista for 5 years. You understand how easy this is when you see what's going on? Now, what is the avoidance? Well, remember, it comes to allocution, but not really. Pardon? Pre-sentence read. No, you're going to see where this fits in. Don't jump ahead. Stay on track here. Okay? Remember, what is Paul Harvey's afternoon program called? The rest of the story. And what does he do when he does his little things in the rest of the story? What's he tell you about? Things you generally never heard about with respect to the main character of which he's telling you. Right? Now, when the plaintiff puts his facts into his complaint, how many facts is he going to put into that complaint? Only those which favors him. What happens is the offender's got to come in with the rest of the story. And if he doesn't come in with the rest of the story, he's not going to do an avoidance. And if you only accept the plaintiff's facts, which are a small subset of the whole truth, you're going to get the wrong conclusions of law like he's got in his complaint. And you're going to go to jail because you're Saddam Hussein, according to his complaint. So what you need to do is come in and do a Paul Harvey and give the rest of the story. Now, we've used that example time and time again of the guy standing in the parking lot with the gun in his hand with the bullet that's in the body of the dead corpse laying in front of him, and the cops roll up to a stop, squeal, get out with their guns drawn and say, hands high, you're under arrest for murder. So in the indictment, information, complaint, whatever it is, it's not real anyway, it's only an illusion. They're going to say that the defendant was found standing in the parking lot over the dead man with the gun in his hand. The bullet in the dead man came from the gun that was in the hand of the defendant standing in the parking lot. He was the only one there when the cops arrived. The guy was dead, obviously. This guy shot him, and we're charging him with first, second, third-degree murder. Now, what you do is you come up with some extra facts, not those that are in the report or in the complaint. You come up with the fact, yeah, but before the cops got here, which was 5 minutes after the guy was shot, the third guy, the one that really killed him, was here. I wrestled the gun away from him and he fled. Now, based on that additional facts, what would happen to the conclusions of law now? Would the guy who's been found with the gun in his hand standing over the dead man necessarily be a murderer? The answer is no. So you confessed all the facts that they stated in their complaint were true, except for the conclusion of law that you were a murderer. You added some additional facts which changed the complexity of the events, so that no longer was it assumed and presumed you were the murderer. You tried to intercede. Unless the state can rebut your additional facts, you have created probable cause for doubt and should not be convicted. Now, how you bring in your facts are by the negative averment. So you do a confession by the acceptance for value, return for value, and ask for settlement and closure, and attached to the return of that instrument, which is procedural, which is the confession side of the pleading, you put in the negative averment affidavit, which enters the additional facts, which becomes the avoidance side of the pleading. Now, you need necessary and complete pleading. It's necessary to confess, to accept and return, but it's also necessary to avoid by adding the additional facts to rebut the presumption of the substantive charge. And if you don't do both to make it necessary and complete, chances are you could still be found guilty because of the presumption you did the crime in the substance, unless you put in the negative averment to overcome that by the confession and avoidance. Now, let's say you put in the negative averment and it's on the private side. What does that tell the court? It tells the court you're not the bad guy when it comes to the substance of the crime, doesn't it? Unless the state comes back and rebuts it. So now the court, the judge, knows that you're not Saddam Hussein. But you did a confession to the charge. So for public purposes, does the court want to come forward and crucify the defendant anyway? Probably, but who cares? So let him proceed on the public side to crucify the defendant. So they find the defendant guilty in the trial of the defendant, basically because of the one side of the plea, the confession. But on the other side, they saw the avoidance, and did the state ever rebut the avoidance? Chances are they never did. So you're winning on both the substance and the procedure side of the case. even though on the public side they're going to find the defendant guilty. Then comes the pre-sentence report. What's happening with the pre-sentence report? It's a new offer. And this one's directed at the offender. See, if they find the defendant guilty, the defendant is a corporation. It's a fiction. It's a straw man. How are they going to punish the corporation? They can't. It's a pile of paper. It's an incorporation document. What are they going to do? Burn the incorporation document? There, we fixed you. So what they're looking for desperately is they're looking for a partner of the corporation, someone with flesh and blood, that they can punish. So they're looking for someone that's gone into partnership with the defendant. When you come into allocution and you start arguing the defendant's report in the pre-sentence, you are now demonstrating that you are the partner of the corporate defendant. And by demonstrating that you're the partner of the corporate defendant, whatever punishment went to the defendant goes to you now because of your partnership. So when that pre-sentence report comes out and they offer it to you, what do you got to do? Accept it for value and return it. Does that work? Yes. Beep. Wrong. What happened to the guy that went to sentencing that says, I accept it for value, return it for value, put it on the case file, put it on top? Judge said, fine. Anything else you'd like to say? When they offer you that pre-sentence report, you got to do a confession and avoidance to it, just like you did a confession and avoidance for the defendant in the original complaint. And if you do the acceptance for value and return for value, which is the confession, and failure to do the avoidance, you have not done what is necessary and sufficient. And the court is either stopped from proceeding until you do enough, or else you're crazy. And they can't give you a remedy. So you accept the offer report, you return the offer report, and again by a negative averment of some kind, you can add some extraneous facts that are not in the report to give to the honorable a colorable path to give you the living soul a remedy. Yeah, or let them know you're really crazy, like, I don't want you to sentence him to anything. Nope, I don't think that's the avoidance we're looking for, all right. It's not colorable enough. So what you see happening here is you've got to understand that what you're doing is a confession and avoidance pattern at each stage. See, it takes a double witness. The first witness is the charging instrument and the trial. The second witness is the pre-sentencing report and how you, as the offender, respond to that. And both have to be consistent. And both have to be acceptance and avoidance, which is the confession, coupled with the negative averment, which is the avoidance, which adds extra material, which really shapes the liability and sheds it away from you. Yes, Caleb.
Okay, why would they, on the first confession and avoidance, if you placed in the fact that, yes, that's the gun, I was standing over it, so on and so forth, but the other guy took off, running away, and so the court just went ahead and rolled over you on that one. Why aren't they going to roll over you on it at the sentencing hearing?
Well, because there is a principle in Scripture which says, it's not what we say, it's what we do. But actions speak louder than words. Do we really care what happens at the trial?
I do.
Why? Are you the defendant?
No.
Okay, then why would you care what happens to the defendant if he's not you?
Because I'm perceived by the rest of the community.
Sticks and stones will break my bones, but names will never hurt me.
Yeah, but if they find the Sticks and Stones guilty and put this Sticks and Stones in jails for 40 years
Hang
or
on.
100 years.
Who puts them in jail? The jury or the
judge.
sentencing judge?
The judge. Sentencing judge.
And you're telling me the sentencing judge doesn't know the law?
Well, I'm not saying that. I'm just asking you the question is why would they
What
honor...
I'm saying to you is it's immaterial what they do to the defendant because you confessed all the facts against the defendant were true.
Except for the fact of actually committing the crime. That's
That
the
was
avoidance.
the conclusion of law. You did an avoidance, okay.
So that's the avoidance.
So what he's doing is he's saying, I can hear you, but I'm not going to hear you. Not for the public. I'm not going to hear you. Now, the only issue is where the rubber meets the road is they don't care what they do to the straw man. It's their straw man. They created it. If they want to drag their straw man through the mud, they can drag the straw man through the mud. Who cares? You're going to say you care because he's my straw man. No, he's not. Unfortunately, you grabbed yourself on him because you thought he was important to you. But actually what happened is they sent him out there as the snake in the garden for you to grab and get bit. And now you want a nicer snake, but he's not your snake. Okay? So the issue is, you're really upset. You want to defend the defendant so that he has a nice name for himself and everybody in the community looks up to your straw man who's a really perfect guy.
Not necessarily, but I don't want the whole community to come in and saying, hey, he's a child molester if this is what they charged me with, or a murderer or anything else, that everybody goes, he's a child or he's a murderer.
Oh, really?
No.
What do you think they were calling the Messiah? Lots of things. In addition to everybody else, they were calling him lots of things, and there were lots of those disciples and apostles and everything that were in jail. They weren't in jail because they were nasty guys. They were in jail because people wanted to get rid of them because they were interfering with the system's commerce. It's not about protecting the name of the strawman corporation that they created. It's about knowing whether you're right or wrong. Lee.
This is Lee Bernstein. Maybe this will help Caleb out a little bit. He is involved in a situation where we went to Columbus and the court wrote in the public document that there was an unauthorized practice of law. Isn't it very interesting? Because I have read hundreds and hundreds of case laws and found out they're all fictitious. You can read case law, all fictitious. It's just their public posting. It had nothing to do with the proceedings. It had nothing to do with the outcome. You can study it all day long, and you can have those fictitious attorneys go up there and celebrate in their theatrics and their pronouncement of this case laws. It's all fictitious. What stopped everything was the confession and the fact that everything was returned with a negative averment. Every time they tried to serve this thing, it was accepted for value, returned, state your claim, and with a negative averment. Until they finally gave up and says, well, if you're going to keep doing that, we're not going to serve you anymore.
So they went away.
So they went away.
So Caleb was accused of raping a lawyer's business.
Absolutely.
And that's why he's so upset.
And he's still upset about it because it's written down where he can read it.
His straw man is a lawyer.
Oh, my goodness. So that's why he's upset.
Okay.
He doesn't want the public to see that.
Oh, he's proud of being a lawyer raper. Have we successfully twisted your words now, Caleb? Okay, the point we're getting at is that you've got to look in terms of the confession and avoidance. It's a two-part. And that's where the negative averment comes in, and it's usually on the private side. Now, the thing that Caleb was upset about is that if they find the party guilty in the trial, what are they going to do at the sentencing? And what we're saying is that the sentencing is a separate but